Okay, here goes the update on this case entitled. They they made a filing yesterday around 12 o'clock, 12:25, 6 pages. They kept the name right there as the plaintiff versus California State et al. And I'm showing you that this is not how I filed it. I filed it as ni, nay, in, small I, small I. There was a glottal stop in there, and then in, e, glottal stop, e, glottal stop. High tone diphthong. So this is not the correct title. They changed it to entity versus an entity. That these courts know that the living cannot commingle with the dead entity. And this is supposed to be where that red, white, and blue flag flies. Didn't want to honor my motion to reopen it. And instead, they want to make a new findings and recommendations on 12/12 that they are saying that they're saying that they made these decisions right here now. Zoom in a little bit here. Plaintiff who is proceeding pro se brings the civil action pending before the court is plaintiff's motion to reopen case, and this is in that number 22. In the background on October 24th, this court dismissed plaintiff's complaint, finding the claims presented in the plaintiff's complaint were frivolous. Frivolous. How is it frivolous when I already won 27 charges of genocide? And I'm telling you, your judges are treasonous. And you all thought that I was an entity playing along. So, right here, the court dismissed my complaint findings presented were frivolous, and plaintiff provided very little factual information underlying his claims. But if any of you goes and looks through everything that is not frivolous, and there's a lot of affidavits and exhibits to back up my frivolous claim here. And how frivolous is this? Well, I made this claim right here. These people, Gavin Newsom and all of them, for 666 21 zeros, gold mint, for gold mint coin, not counterfeit, that dollar shit paper that doesn't hold value. It doesn't have any gold on that dollar bill or the $100 bill. So in this claim, it is for 666 21 zeros, frivolous. I already been through this a lot of times, so I've been making all these frivolous claims, I guess, and I don't settle with them. I'm not in this to settle with them. I'm here to talk about the Turo Wampum Treaty Belt and Rosetta Stone and Chanupa and this treaty called 1868, made with the Navajo tribe of Navajo, 1868. My forefathers were involved in those conflicts. So I am the great great grandson. We are the heirs, and we still uphold our end of the peace agreement that we would stop scalping you, motherfuckers. Scalping you, yes. On us trespassing and not paying us rent, homage for crossing through I-40 or 666 or any of these roads. You're behind on rent. So I talk like this on this video to show you I took it all the way to the federal court to say you're behind rent. And you want to sit here and play this bullshit here, but I'm really playing with you. On April 24th, 2025, this court dismissed plaintiff's complaint, finding the claims presented in plaintiff's complaint were frivolous and plaintiff provided factual information underlying his claims. C and ECF number 13. Out of an abundance of caution and because the state court transcript plaintiff provided. What the fuck just happened? I don't know why this thing is fucking up. God damn it. I don't know why this thing is fucking up right here, but okay. On April 24th, I gotta start over. Now, to the next page. I already read this one. Plaintiff filed what the court construed as a first amended complaint. That's number 14. Construed. They want to be the authority. Remember, this entity people, but they are not the true authority. So they try to play around authority. Plaintiff filed what the court construed as a first amended complaint, number 14, but this court issued findings and recommendations recommending dismissal of the action for failure to state a cognizable claim because the first amended complaint made the same broad assertion that defendants violated the Two-Row Wampum Treaty without providing facts to support this allegation. So that's all bullshit. That again, in the court case in New York, the Two-Row Wampum Treaty Belt won the court case. So this stupid fuck right here are stupid fucking people you guys call judges. Yesterday, last night, I showed you all that in this. So go back to part 2 and you'll see what I showed you there about this Two-Row Wampum Treaty Belt. I provided this court right here facts that I already won 27 charges of genocide and I didn't settle with them. And it's never been overturned. So this is how ignorance is in California under a democracy. This is what you call your democracy right here, is to play against the rule of law. The Two-Row Wampum Treaty Belt, clan mothers and headmen. This is why it is flooding. This is why it is the ring of fire and California will fall in the ocean. And it already is as we speak. And you can all go thank Gavin Newsom and his buddies in these court buildings in Sacramento DOJ, Rob Bonta, all of them. They all have my record and file. I put it back in this court, the whole DOJ file. That my name's not any alias, only Nene. So this court is protecting Rob Bonta and Gavin Newsom and what you all call democracy. And number five, the district judge adopted the findings and recommendations in full and dismissed the action with prejudice for failure to state a claim upon which relief can be granted. Plaintiff subsequently filed exhibits number 22, 25, 26, a motion to reopen the case. Number 22, a notice of proof of service of writ of habeas corpus. At this time, this case is over, that there's no NII capital letters, NEE capital letters, filed in Navajo County. The judge referred the motion to reopen the case to the undersigned pursuant to 28 USC 636B1B and Local Rule 302AC. Number 23, in the motion to reopen the case, plaintiff contends that he never received the findings and recommendations issued on July 2. Number 15, number 22, plaintiff contends that the exhibit he filed September 22, 21 explained why plaintiff failed to respond to the findings and recommendations. Plaintiff asserts that he was arrested, kidnapped, detained, and obstructed in plaintiff's full diplomatic status, violating plaintiff's diplomatic immunity at the Navajo County Sheriff's Jail in Arizona. CID, plaintiff alleges that he was unable to respond because he was detained from July 28, 2025 until August 14, 2025. CID at 2. According to plaintiff, he filed a writ of habeas corpus challenging his detention in Arizona because it is the law of the land. Article 6, Section 2, and the Supremacy Clause pursuant to the Turo Wampum Treaty Belt that plaintiff Nene carries. Attached to the motion is a document that appears to be a record of plaintiff's habeas petition filed in Arizona Supreme Court, page 3. Writ of mandate drafted by plaintiff, pages 5 through 13. Plaintiff's habeas petition filed in the Superior Court of Arizona, pages 15 to 21. A determination of release and order, right there, it was ordered that. That means that this is right. If this is all right over there, then it's all right over here. It works in every court. The living wins in a dead entity court and over the dead entity. And these judges are just bar numbers. So pay attention here. All this goes to appeal. And attached to the motion again is appears to be a record. Appears, he says, appear, disappear, appears, and then it appears there's a document attached to the motion to reopen it. Now, if you are a judge, you decide if this people is wrong, and if you're gonna help investigate this shit, corruption of crooked judges that should be hung for treason, subsection 2381. Well, here's Coggins and Cota, and Rob Bonta, Gavin Newsom, TJ Linville, Joanne Bichego, John H. Lawrence, Siskiyou County Board of Supervisors, their court system, their newspaper writers, their transcript people. They're not all blowing the whistle or anything. So, but I tell you, the Churo wampum is in place at California and Oregon and Washington. So there's some things that I attached that they 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 dropped the fugitive complaint right here. A Superior Court of California for Siskiyou County warrant for failure to appear. A Siskiyou County Jail Transportation Unit fax to Navajo County Jail. Page 28. New York documents, page 29 to 30. An irrevocable covenant power of attorney in fact. Right here, Judge, the one that took constitutional oath that these you make the call on these other judges. And irrevocable covenant power of attorney in fact, pages 31 through 34. Arizona Corporate Commission documents, pages 35 to 39. California records regarding limited liability corporations, pages 40 through 48. New York court documents filed. Plaintiff, pages 49 through 52. A record of dismissal of charges against plaintiff in New York, page 53. Court documents filed by plaintiff in New York, page 55. And an affidavit in support of motion to proceed in form of paupery, pages 56 through 60. CID. So all that was a certified case of the mandate order that was filed in Albany, New York back in 2016. In plaintiff's September 22, 2025 filing, plaintiff asserts that enclosed are evidence documents of obstruction of a diplomat while I, Nene, went on travel. Right here, look, you see how they do one in capital, one small I, and then one capital I right there. All their little bullshit fraud that they're doing even on this case. So you have to pay attention. Those aren't just little typos. If I have to make my shit good, they got a lot of um, secretaries and shit at their office, clerks, and everybody's held accountable for what they write on these things. 18 USC 2076, 18 USC 1512B, that these clerks are held liable for their part in these. So this order minute entry thing right here got to be real pretty, but right there's a fraud. Are you referring to Nene the diplomat, and why are you putting an I in there to make it a different name? So plaintiff asserts that enclosed are evidence documents of obstruction of a diplomat while I, Ni, and then I, and then Ne went on travel to Clan Mother Headman. I was kidnapped. That's in number 21, page 1. Plaintiff asserts that he attached a writ of habeas corpus. He filed his international passport and irrevocable covenant power of attorney. The documents attached include a counter complaint filed by plaintiff in Arizona, pages 2 through 7, and the same documents attached to plaintiff motion to reopen. Cases, page 847. Plaintiff did not attach the affidavit in support of motion to proceed in form of pauperis that he included in ECF number 22 to this filing. See ECF number 21. In plaintiff's notice of proof of service of writ of habeas filed in Navajo County. Plaintiff provides receipts from U.S. Postal Service showing mail sent to Sacramento and proof of service drafted by plaintiff regarding writ of habeas corpus. Plaintiff filed in Siskiyou County Superior Court. So everybody got served. TJ, everybody. And they don't want to get hung, so they had to go do some bad things to get this to happen right here. And I don't want to know what kind of shit they do, but they had to do it. So some of you are missing people and things like that over this right here. And them too, they're missing relatives. These are Jesuit order people, Lopez cartel, Garcia cartel, in cahoots with Katie Hobbs too down here. Jesuit orders who we're dealing with here. Israel fuckers and all them towelhead ones. Remember, there are slaves. There's the notice of proof of service that this writ of habeas corpus was filed in Navajo County. Plaintiff provides receipts. Plaintiff provides 35 pages of what appears to be court documents and filings. They don't want to explain what it is. It's the writ of mandate order that they dismissed the case out of New York, and I filed 27 charges of genocide. They don't want to be explaining it too much. They don't want to tell you in any of this that the plaintiff already won 27 charges of genocide and never settled. So I'm here to narrate that for you. The court may grant reconsideration. Oh, wait, right here. Plaintiff provides documents he filed in Siskiyou County, pages 3 to 15, and 100 pages of court documents filed in California, Arizona, and New York, most of which were provided already prior. The court may grant reconsideration under Federal Rules of Civil Procedure 59E and 60. Generally, a motion for reconsideration of a final judgment is appropriately brought under Federal Rule of Civil Procedure 59E, Backlund versus Barnhart, discussing reconsideration of summary judgment. See also Schroeder versus McDonald. The motion must be filed no later than 28 days after entry of the judgment. So I got 28 days, I guess, right here, everybody, if I want to continue on. But I can tell you there's no justice from this court right here. You have to kick it into another court, international, and violate them. I invoked all this court right here, Article 3, Section 2 court. And this is how they treated it. So I have no choice but again to up it up to international criminal court. The court may grant reconsideration. May grant. I'm not asking if it can or will. You guys already are corrupt, so it's proven now that you're protecting Gavin Newsom, Rob Bonta, the Supreme Court, Simone Bolts, and George Navarrete, and all of them crooks over there. Everybody was just trying to get into the trust account that has gold that I already took from you. And you've been trying to get it back all these years. Since 2012, I've been sitting on a lot of gold. And I took that belt away from the Iroquois. So anyways, the motion must be filed 28 days, and then under Rule 59, 3 grounds may justify reconsideration: an intervening change in in controlling law, the availability of new evidence, or three, the need to correct clear error or prevent manifest injustice. See Kern Tulare Water District, City of Bakersville, reversed in part on other grounds. So that one was denied, but so they cited some bullshit that doesn't have no relevance to nothing. I'm a native, full blood. On stolen land, these people act like their cases mean shit, but they're all entities. None of them are the true inhabitants, original. So to me, none of this shit matters. I'm full blooded Dine. No caught Dine. And my full identity. This is for all of you other kind, citizens and private citizen, national, or whatever your title status might be. But none of this has to do with native. No relevance that have treaties or anything. This is all out the door for me. It doesn't have nothing to do with me. Who wrote this federal book? That guy's name's Cohen, Cohen. How did he get to write that book called a federal criminal book on natives? How did he get to do that? Iroquois. He was Pocahontas in Iroquois to get into write a federal law book such as this shit right here. And this doesn't really have no relevance to me. I'm just showing you all some shit that I'm not under state or federal. I'm just showing you all that it's crooked at the state and crooked at the federal. And they make you all have a hard time with all this kind of shit, so you gotta know what to do. I'm showing you what I'm gonna do again right here, that this doesn't have nothing to do with a full-blooded native that has treaty rights and claims Article 6, Section 2. Which one of these cases called, show it to me that there's Article 6 section violation, because that's what this whole court is about. It's about these motherfuckers violating a treaty. I don't give a fuck about this over here. So under federal criminal Indian rule that this Cohen wrote, Rule 60, the court may grant reconsideration of final judgments and any order based on clerical mistakes. Well, there's some mistakes on there. I just showed you one misspelling of my name. Relief under this rule can be granted. So all I'm going to do is say you better reconsider and that you are capitalizing my name into capital letters. Hokahe, Warriors to front. under Rule 60 is where I was at right there. We had a little technical difficulty. Should na yate. Kuro e yahanet hitchenanishla. In my court case that is in California Eastern District, Robert Matsui Federal Court Building, 501 I Street. That's where the court building is at. I am over here at Arizona, and I was just finished reading about a habeas corpus that I filed in Arizona. So the court case from California had a stay order on it. Right here, this federal court, and then the Siskiyou County Court, and its crooked judges wanted to play. They wanted to gamble, tried to get me arrested. They did get me arrested, and my partner over here in Winslow, Arizona. So we came over here for a court date, and I share with you all. My friend, she's not a descent of DINE, my tribe, my clan people. She is descendant of the Asias, and she carried a 2-row wampum treaty belt that I carry because I have peace with her, and she's a living woman. She's an entity. She doesn't go along with the Social Security as her identity. She has learned to say she's a living woman in the court over here at Winslow. So I sent her in there with the 2-row wampum treaty belt, and she filed a motion on it in a kangaroo court. You had to say everything in the kangaroo court. So she did that. No Miranda rights read, no oath of office, no disclosure of witnesses. There was no injured party, and so B.J. Little is that judge's name over here in Winslow. B.J. Little, and the district attorney Chris Coyne, a British agent, registered with the Secretary of State here, Adrian Fontes. So, Adrian Fontes, you have a problem with county and every county that, and probably yourself too. You got to go look at to see if you are immoral. But back to this, they denied my my motion to reopen while I'm being held, kidnapped, and I got out on a writ of habeas corpus. They still want to deny it. So hopefully the next appeal to this, those judges are a little bit more constitutional than this one again. But that's all you can pray for. This is all entity shit, state or federal. I'm not under them, so they haven't even proved that they have correct jurisdiction to play in this. That's why they capitalize the letter and things. Again, the living man, woman, child can't just go and commingle with these entities like what I'm doing right here. I'm just exposing it. They can't even spell my name right in the case. Small letters. That's what it means. The court may grant reconsideration of a final judgment, any order based on mistake, inadvertence, surprise, or excusable neglect. So they made a mistake on this, and all of this, all of the above. Newly discovered evidence. Well, the habeas corpus is in there. and could not have been discovered within 10 days of the entry of judgment. So there's a fraud also going on, misrepresentation or misconduct of an opposing party right there. So all of this shit is relevant to a appeal, and that's all I'm gonna do is grant write this shit up the way they try to tell you to do it again, and and this is not my This is not my expertise of sitting here authoring things. I do it because they force me to, but I don't have a taste for this shit. So that's all they got on me is that I don't give a shit for all the spells on paper. But again, I already got them back in a lot of times. The judgment has been satisfied. The judgment is void. Has been satisfied, released, or discharged. An earlier judgment has been reversed or vacated. Well, the habeas corpus trumps all of this, so they're having a really hard time, like the snake eating itself. Two snakes coming to each other, state and a federal one, and they both got to eat their tails. They got to eat themselves or eat each other. That's what's happening right here. And the nah we call it the monster slayer happened. Naye nezgane happened. Tobachis chine happened over there by the ocean, born of water. And the monster slayer songs happened right here. I already told everything that's right here. I said return the bonds. There's no longer no equitable anything. The man wrote a habeas corpus to secure himself, whether in this court or another court. So they just want to skip out of this, and they don't want to tell the world that yeah, there's treason on the judges. Under Rule 60B, the court may grant reconsideration of a final judgment and any order based on mistake, inadvertent, surprise, or excusable neglect, newly discovered evidence which with reasonable diligence could not have been discovered within 10 days of entry of judgment, and fraud, misrepresentation, or misconduct of an opposing party. Well, I proved that. Just TJ Linville still issued out a warrant on the false name, Joe Emerson. The clerk was still hiding the facts that they received on the 25th and the 29th. It's all in here. So, Federal Rule 60B13, a motion for reconsideration on any of these grounds must be brought within 1 year of entry of judgment or the order being challenged. So I can do one in 28 days, one in 1 year, and this whole thing in 14 days. That's what it looks like in this big kangaroo court to me. I don't know. They're all kangaroo courts. Any other reason that justifies relief? The judgment under Rule 60B13, a motion for reconsideration on any of these grounds must be brought within 1 year of entry of judgment or the order being challenged. Under Rule 60B, the court may also grant reconsideration if the judgment is void, the judgment has been satisfied, released, or discharged, an earlier judgment has been reversed or vacated, or applying that judgment prospectively is no longer equitable. Any other reason that justifies relief. So basically, I rewrite this shit and tell them it's right there already in your stuff. They really want you to tell you this is how it's affecting you, I guess. And a motion for reconsideration on any of these grounds must be brought within a reasonable time. Within a year, it said up there. Then it says within a reasonable time. I don't know. As a preliminary. Shit. Okay. I don't know what the shit happened here again. Okay. I'm sick of doing all this computer shit. asked them at Winslow High School or Winslow Junior High or Cedar Public School or any school. I asked them if I ever took any computer literacy. Never. Discussion. As a preliminary matter, it is unclear how and whether the documents attached to plaintiff's motion to reopen the case apply to the present action. See how stupid the entity is? Many of the documents are dated years before plaintiff initiated this action and are filings in states other than California. Those are called historical precedent case law, idiot. The only documents that may have bearing on this case, plaintiff's affidavit in support of a motion to proceed in form of pauperis, is inapplicable because the court already granted plaintiff's motion to proceed in form of paupery. Paupery, some bullshit like that. I don't know what language they're talking. This is old fish English. As to the delivery of docking filings and dismissal of this action, this court's findings and recommendations issued on July 2, 2025, ECF number 15 were returned as undeliverable on August 12, 2025 and August 19, 2025. Plaintiff filing notice of change of address August 25 and the July 2nd, 2025 findings and recommendations were reserved to that address. The district judge adopted the findings and recommendations over 14 days after the findings and recommendations were reserved to the address. Plaintiff provided that then see number 18 that is the same address that plaintiff provides in his motion to reopen the case. Service upon of the findings and recommendation was effectuated August 26, 2025 to that address. Nothing ever came to any address, any of my addresses, or an email or no phone call, nothing. And I call in on a weekly basis to do a status check on this. So people that deal with crooked judges, you know the game and the clerks. Though plaintiff asserts that he was, so it's good to always record when you talk to the clerks and stuff. So I got about a lot of audios I'm gonna upload to the YouTube. You can listen to me talking to these people and to the court clerk at the other case, Supreme Court. So both of these cases, Supreme and Federal, they both were in cahoots yesterday on the 12th. And they all gambled again, like back in 2012. But you can see the ring of fire is blazing hot. Get your marshmallows, fry some fish up. Fish fry, Friday, right? Chris Mays, right? Rob Bonta. It's fish fry Saturday today at the Clear Creek. And the Nimrods, they didn't pay, so you know what it means. Lopez gonna eat you, and Garcias are gonna eat your children. They know the score. It's not my children gonna get eaten. Your children get eaten. Though plaintiff asserts that he wasn't able to respond to the findings and recommendation because he was incarcerated in Arizona from July 28, August 14, 2025, as noted above. Service of the findings and recommendations was effectuated August 26, 2025, after plaintiff alleges he was released. Nothing ever came, and I called and let them know. Though plaintiff contends he has received no legal mail to the address he provided, all filings were sent to that address. How come you didn't write that address? Which address did you send it to? So show me some proof that you really sent it to whatever address that you're saying. All filings were sent to that address. What address? And service was effectuated upon mailing. Okay, so prove it. I back mine up with the green card return receipt. When you're in a court case, you have to make sure those people are proof of service. You have to prove of service. And you're supposed to be for the law. And the law is supposed to be for the living, not the dead entity. But this federal court is leaning to the dead entity. You all can see it. And even entitied my name to capital letters. So you have no choice but to file charges against all of these people too, and the Supreme Court. And me, I don't like doing all this, like I said. So I'm showing you that do have the belly for this and the credit cards and time on your hands to address the Constitution in California. That this is happening from Gavin Newsom's orders and the DOJ, Rob Bonta. Though plaintiff asserts that he was unable to respond to the findings. The court notes that plaintiff's action was not dismissed for lack of prosecution and failure to comply with court rules and orders, but rather because plaintiff's first amended complaint. I never made a first amended complaint. So again, they're bullshit, and I never made any amended complaint. I've never amended nothing. I left my shit all the same. Failed to state a cognizable claim, and the claims presented were frivolous. And I already showed you all. My claim is treason. You're violating the two-row wampum treaty belt, trying to to prosecute a living headman under his clan mother authority. And I already shared the court case with you where the two-row wampum treaty belt is won in the genocide claim. 15 and 18 plaintiffs' recent filings make the same broad allegation about the two-row wampum treaty belt without providing facts to underlie the claim. They have the case. How do you not have the facts? And almost entirely consists of irrelevant court documents from other states, and they're all precedent cases that say two-row wampum treaty belt. Years before plaintiff initiated this action, thus such filings do not demonstrate that plaintiff can remedy such deficiencies. Plaintiff's motion, yeah, I told him that. Don't order me what to do. So he knows it that I'm telling him and her. Thus, that such filings do not demonstrate that plaintiff can remedy such deficiencies. I never amended nothing, so they're just making some extra whole paragraph of bullshit right there for no reason, but to back up whatever their idea is, why they deny to resend the findings and recommendations. If it's so solid, they should have had no problem to resend the motions, but there's a problem because they know this case is fucking them up pretty good. And if you want a federal law, you gotta correct all this shit. Your mistake on your decision there, Coggins, Kota. Plaintiff's motion does not meet the standard required for reconsideration pursuant to federal rules of civil procedure. 59 and 60. Plaintiff alleges no clerical mistake, provides no newly discovered evidence, nor asserts any fraud or misrepresentation by any opposing party. Holy fuck. Everything is I showed as fraud that they got the wrong name, and I gave them certificate of no records of the false ghost name. So plaintiff may be intended to bring such motion to allege excusable neglect. However, as explained above, this action was not dismissed for lack of prosecution or failure to comply with court rules and orders, and plaintiff's contention that he was unable to reply due. Now I want it to change page, and this fucker don't want to do it. Okay. Due to incarceration is insufficient because plaintiff asserts he was released before the findings and recommendations were reserved to plaintiff's address. Again, what's the address? Based on the foregoing, the undersigned recommends plaintiff's motion to reopen this case be denied. Recommends. So here's their new. These findings and recommendations are submitted to the United States District Judge assigned to the case. Pursuant to this, within 14 days after being served with these findings and recommendations, any party may file written objections with the court. Responses to objections shall be filed within 14 days after service of objections. Failure to file objections within a specific time may waive the right to appeal. Now, again, I really don't give a fuck. This was my whole purpose, was to let you all motherfuckers see that courts are crooked and you better know what the fuck you're doing. And they do things on certain dates, their calendar, not my calendar. I live by 13 moons. They try things on their calendar, like 12, 12, 12, thinking that they can usurp the great authority of the sun and the moon. So it looks like I got 14 days to decide if I want to pursue this any farther. And right now, a lot of you Navajos, you're not worth my time to try to be an example for you to learn some case law, court things, and what I'm going through. To a lot of you would have quit, not even to hear. You wouldn't. You can't even consider doing this shit. You like to just complain on Facebook. Edo oliera. Aho echet egot eyai na achish. That's not what we say to our children, but to my children right here, this is not your this is not your dad. To my clan born for and extension families, clans. I have to call these people out that they're capitalizing my name right there. It's not how I spell my name. In their findings and recommendations, I got 14 days. They don't, even though they don't want to reopen it, they're saying they're not reopening it, but it's open. It's going on right here. Look, or I wouldn't have get this shit right here. But the most important thing for all of you is that you saw this document. It's on YouTube right now. You can. I'll scroll through it slowly so you can take a picture of it if you want. Put it in the history books. Go hit Boo Nygren with it. He's playing with my gold over there. He doesn't fight no court cases. When did he fight the United States Cavalry for 666 21 zeros? That's why these guys are denying everything right here, because they got to pay that amount, and they know I'm not going to settle. I never settle. That means do a deal behind the doors. Take the counterfeit. Run. So there you guys go. Do some homework. If you like to know about the federal court, I'm going to go print this out and I will send it back to these people and answer all the bullshit that they said that I did wrong. Just like what I was talking about while we're viewing it. Anyways, yate, shalkahasito, unchi, nacha, warriors, dog soldiers, akichita, tioshpai, dene, kia ani, hanagani, disni, twitichi, ni la. This is for you to regain your authority. I hope it gives you some hope. So the zinbai nudging, wajonastli, 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 wajonastli. I remember my friend, oh, Edward. Oh, and to Amanda and to your mom and dads, to Free, Pero, and to everybody that checked in here. Appreciate you. Thank you. I don't know some of you. I remember a few of you. Yeah. Blessings to Oregon out that way, Wolf Creek, and out towards the Hewitts over there, Oregon, and over there to Cali, to the warriors out there in the hills. We're okay. Jonas Lee, Hokahe, Aho. Bless up. Put the cedar down.